Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. California, we get to talk again. Listen, when I was a much younger trial lawyer and hanging around a bunch of older, much saltier, much more experienced trial lawyers, they used to tell me all the time that, hey, listen, if you're not losing trials, then you ain't trying enough, kid. And that actually in some ways turns out to be true. Well, the good news, California, is you apparently are getting your money's worth out of your attorney general, because Rob Bonta is doing a lot of losing, and he's been doing a lot of losing lately, and he's done it again. This time with that goofy little law down there in California that prohibits you from purchasing any more than one firearm in a 30-day window. Yeah, apparently a judge has said that is no good. It's got to go. So today, let's spend a few minutes. Let's break it all down and let's talk about California court rules. There is no quota on your Second Amendment rights. Okay, the case we're talking about today is Nguyen v. Bonta. We'll get to that in just a second. The first person to alert me to this, of course, was our first ever California subscriber. That, of course, is Philip P. Philip P. has been subscribing to this channel since I was rocking this killer COVID do right here, and he's been spreading the gospel of Washington gun law down there ever since. So, Philip P., this one is for you. This is the case of Nguyen v. Bonta. It is brought to us by our good friends at both the Firearms Policy Coalition as well as the Second Amendment Foundation. This is a case which is filed in the United States District Court, Southern District of California. No, this does not involve Judge Benitez. There is a different judge who has slam dunked on the state of California this time. This is a challenge to California Penal Code 27535, which for whatever reason limits the ability of a California resident to purchase one firearm for every 30 days. Now, I know some of you think like, hey, that's just a crazy California law, so it really probably doesn't apply to us. Well, first of all, Washington State, let us remember that that bill was kicking around in Washington State this year. I've seen this bill pop up. Where the crazies start in California, it spreads like a bad cancer, so everyone does need to be aware of this. Now, in this suit, both parties, that is both Nguyen and the state of California, are actually seeking summary judgment. What is summary judgment? Summary judgment is where one side says to the judge, hey, listen, there really is no dispute as to what the facts are here, and there really is no dispute as to what the law is, so why do we even need to have a trial? Let's just get this over with, rule in our favor, we'll call it good. And both sides were asking for that, okay? Now, California's argument is the classic example of how I always say you got to be very careful about the words you choose because they will build a mountain out of a molehill. Believe it or not, California's entire argument spawned from the Heller opinion. Really? How so? Listen to this quote. Although we do not undertake an exhaustive historical analysis today of the full scope of the Second Amendment, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. So what California's position is that this has nothing to do with the right to keep and bear arms. Yes, this may hinder their ability to accumulate or purchase them, but since we're not affecting their right to keep or bear, hey, no harm, no foul. And as the court pointed out, not only was this a rather perverse argument, but the Ninth Circuit, shockingly, had been complicit in this, as they basically had punted on any case that dealt with the commercial regulation of firearms. As the court put it, as a result, the Court of Appeals for the Ninth Circuit has often avoided having to define the contours of the commercial sales category by assuming, without deciding, that the challenged regulation was not presumptively lawful and instead upholding the regulation under the appropriate level of constitutional scrutiny at step 2 of the pre-Bruin analysis. And therein lies the problem for the state of California on this go-around. You see, there was an old test, and now there's a new test. And the court points out both of them. The old test, one approach urged by the defendants and taken by the Fourth Circuit prior to Bruin, is to treat a commercial regulation as presumptively lawful if it does not act as a functional prohibition on buyers. In determining whether a commercial regulation amounts to a functional ban, Hirschfield instructs courts to consider the severity of the restriction and whether it substantially burdens a group's rights. But as you can see, that is a test that is completely based in balancing. So what's the new approach? Well, the court points out, Bruin suggests that the proper question in evaluating whether a regulation falls within the commercial sales category is not the extent of interference with the Second Amendment right, but instead whether the regulation historically would have been tolerated. And so ultimately the court rules that this activity, the right to acquire, to possess, to purchase a firearm, is the type of activity which is covered under the plain text of the Second Amendment, which means now the state of California has to justify the existence of this regulation through historical analogs. And as usual, this is a big, big problem for the state of California because, well, shockingly, none exist. So what does the state of California do? Well, again, they tried to build a mountain out of a molehill and take one tiny little sentence out of Bruin to say, hey, kind of all bets are off here and we should really come up with a whole new analysis. The quote, thus, regulations addressing unprecedented societal concerns or dramatic technological changes may require a more nuanced approach. And the court actually says, okay, you know what, in arguendo, we'll just go ahead and give you this nuanced approach, but you still need to come up with historical analogs. And what were the historical analogs that the state of California came up with? Yep, you guessed it, the usual suspects. For the purposes of the analysis below, the court will assume that a more nuanced approach applies. Thus, to meet their burden, defendants must produce historical regulations that are, quote, relevantly similar, end quote, to California's one gun a month law. Defendants offer historical regulations that fall into 4 categories. 1, gunpowder regulations. 2, restrictions on the sale of firearms to Native Americans. Damn, California, really? 3, restrictions on deadly weapons. And 4, taxing and licensing regulations. And without getting too deep into it, you know where the court goes with this, which is, hey, listen, even if we're giving you that more nuanced approach and you just need to come up with something that's kind of relevantly similar, yeah, you guys haven't even carried the burden of proof here. As the court ruled, defendants have not met their burden of producing a well-established and representative historical analog to the one gun a month law. The court therefore concludes that plaintiffs are entitled to summary judgment as to the constitutionality of the one gun a month law under the Second Amendment. A huge, huge win, California. I am sure that Rob Bonta and Governor Newsom have already soiled their pants. I am sure that right now they got a couple of poor young schmucks working overtime at the Attorney General's office right now, drafting the appeal and the immediate stay they will ask from the Ninth Circuit. So this is California. This is a long way from being over, but it is a big win. It is a huge win. Kudos to the Second Amendment Foundation. Kudos to the Firearms Policy Coalition. Kudos to all the plaintiffs in this case. The case, once again, is the Win v. Bonta. We will link it up down below so that you can geek out on it for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information, it's also down there in the description box. And then let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.